Okay. All right. Good evening, everyone. Thank you for being here. Thank you very much to Christie for being here yet again. My name's Adam Carson. I am a principal planner with the Rockland County Planning Department, and I'm the executive director of the Rockland Municipal Planning Federation. Welcome to session 2 of our certification series, the update of case law. The Federation is a nonprofit organization. It was formed over 36 years ago. One of its primary functions is to provide and promote educational programs for land use board members so they can make more informed decisions about the development applications that come before them. The certification program is unique. It's unique to Rockland. It dates back to 1993 when all the towns, villages, and the county itself agreed to require its board members to complete the certification. There are 3 sessions, 1, 2, and 3 are given every spring, and session 2, tonight's session, is given a second time in the fall. To become certified, you must complete all 3 sessions, and then you're required to retake session 2 every other year to be recertified. All these sessions also count towards the New York State training requirement for 4 hours. Before we begin, I've got a few housekeeping items. I put in the chat, and I'll put it up again because there's been a lot of chat and it's probably scrolled up pretty far. There's a flyer about the Rockland County Comp Plan update. It's Envision Rockland. There are still 2 more workshops that you can go to, and one of which will be virtual. I'll put that link up again once I'm done talking so you can download this flyer. But you can also get more information at envisionrockland.com. As part of the county planning department, I feel I need to plug that particular program a little bit. Second thing to mention is that session 2 is unique in that we offer continuing legal education credits for attorneys. The New York State CLE board has several requirements that I'm obliged to follow, the most significant of which is the use of attendance verification code words. I'll provide these code words throughout the session. These are only relevant for attorneys seeking CLE credit. If you're not an attorney, you don't need to worry about it. If you are an attorney, I recommend you write them down. I will be giving the first one in a little bit. Once I give them, I will not repeat them later in the session, and I would ask everyone else to please do the same. Additionally, I'm obligated to send out a course evaluation form and an attorney affirmation form to every attendee after this session. I'll do that tomorrow. Again, if you're not an attorney seeking CLE credit, you do not have to return them, but if you are, you have to complete the attorney affirmation form and return it to me. Secondly, just for regular land use board members, the Federation maintains attendance records that we regularly share with towns and villages within Rockland County. So if you are a board member within Rockland County, you do not need a certificate of attendance. But if you are on a board outside of Rockland County and you'd like a certificate, please email a request to me after the session's over. That includes your name, your municipality, and your board. Please know that it may take me several days to get back to all of you. Lastly, your microphones have been muted. So if you have a question, please use the Q&A function. I'll be monitoring that, and I'll relay your questions to Attorney Addona periodically throughout the session. Please limit your questions to the cases being discussed or general areas of law. Christie is not in a position to give advice or opinions on specific projects or active legal actions in your community. Tonight's session, the update of case law, looks at some of the latest developments in land use law, and we're very fortunate, again, to have Christie Addona with us. She is a partner at Silverberg Zalantis LLC, where she works on litigation and appeals as well as land use applications. She advises municipal boards, including the towns of Haverstraw and Ossining and the village of Tarrytown. She counsels parties before land use boards and has worked in a number of Article 78 proceedings, defending or challenging administrative decisions. She further assists firms' clients in drafting commercial contracts, including leases, contracts of sale, construction contracts, advising on employment law issues and commercial litigations. Christie lectures regularly on zoning and land use topics and has been acknowledged in the 2018 through 2023 publications of the New York Metro Super Lawyers as a rising star in the area of land use and zoning. Christie received a BA with majors in economics and history from Swarthmore and graduated magna cum laude from St. John's University School of Law. She is admitted to practice in New York, New Jersey, the Federal District Court of New Jersey, and the Federal Southern District Court of New York. And I believe that is all I have to do before I turn it over to Christie, except I will now give the first attorney confirmation, I just blanked on the attendance affirmation code word. The first one tonight is primary. Red is one of the primary colors. Okay, so that's the first one. And with that, I'll turn things over to Christie, and I will share my screen so we can have the handout up there.
Awesome, thank you. Okay, thank you, Adam, and everyone at the Federation for putting this together. I'm glad that you're all able to be hopefully home and warm as we start to get into the chilly weather. I think Adam kind of went over all of the beginning stuff that I was going to talk about. So I think what we said is we'll stop periodically when Adam has to give the code words, and I'll take questions. But if there are any questions in the interim, if you just put them in the chat function. Adam, I did hide that on my computer because I feel like it would be distracting if it keeps popping up. So if there's something that you want me to address, just let me know. But we do have a lot of content to cover as usual. So I'm just going to dive right in. So the first case is, I have the wrong outline up, I'm sorry. So the first subject is subdivisions, and we have one case on that, which is Denisov versus DeChance. And in this case, DeChance owned a 1.67 acre lot. The lot was created as part of a 28 lot subdivision in 1984 with a covenant and restriction that, quote, no lot shall be subdivided or its lot lines changed in any manner at any future date unless authorized by the planning board. So in 2021, so 35 years later, DeChance owned the property and made an application to the planning board to subdivide his lot. The application made clear that he was not trying to repeal the condition that had been put on the 1984 approval, but that the 1984 approval allowed for further subdivision with the authorization of the planning board. And the planning board did actually grant that further subdivision with certain conditions, including that DeChance needed certain variances and that there was to be no clearing, grading, or other development within the drainage easement that was on the property. Certain neighboring property owners that were in the same subdivision challenged the approval, and they took a different interpretation of this condition. They argued that the restriction said there was no further subdivision, period. And so regardless of whether DeChance wanted to further subdivide or go back to the planning board, he was not authorized to do so, and the planning board was not authorized to do so. In many such circumstances, once a subdivision is recorded and people purchase their properties in that subdivision based upon the subdivision map, then if there are going to be any further changes to that subdivision map, it would require the approval of all of the other homeowners in the subdivision. However, the court disagreed with the opponent's interpretation of the condition on the original subdivision approval because it did have that express qualifying language that stated that no further subdivision was permitted unless authorized by the planning board. So with that specific language, the planning board had reserved the authority to itself to allow for further subdivision even after the map had been filed. That's not to say that there wouldn't have had to be another subdivision map that was filed with the county clerk, but it would just be limited to that lot as opposed to the entire subdivision. If that language had not been in there, if it had just said because the condition expressly, if it just said no further subdivision was permitted, then this would have been a very different outcome. And so I like this case, and I think it's important because it shows how nuanced language in resolutions has to be, and conditions that you put on approvals have to be, because the people who were on the planning board when this subdivision was approved in 1984, more likely than not, and I'm not saying necessarily because I've seen a lot of people who have been on planning boards and zoning boards for decades, but there is turnover. People retire, they move on. So you can't assume that you're going to always have that institutional knowledge of the same staff, the same board members who will recall exactly the rationale behind why that was done. And so I think this is important just to clarify and to keep in the back of your minds or the front of your minds when you're taking actions like this, that you want to be very careful and always try to be thinking ahead about what could be coming down the pike, because especially with the subdivision, you do a subdivision now, but who knows what people are going to want to do in the future. And so if you anticipate that further subdivision could be an issue, then you do have that ability to put restrictions on if and how that could happen. And as far as the record and the environmental review in this case, the court did review the record, because remember, when the court is looking at these types of issues, they're not looking at it to make a new determination. They're looking at what the planning board did and determining if it was appropriate. So they looked at the record, and they found reports from an appraiser, a contractor, and the town's Division of Environmental Protection, all of which had affirmed that there would not be any adverse environmental impact from this further subdivision. And also putting the additional condition on the 2021 approval, there would be no clearing, grading, or other development within the drainage easement. The court used all of this once it determined that it was appropriate for the planning board to even consider the further subdivision. This justified why it was appropriate in this situation to grant the further subdivision. So special use permits. 853, 855 McLean LLC versus City of Yonkers. This one's close to my heart because I used to live on McLean, and I know this gas station. So petitioner operated a gas station and proposed a convenience store. So the gas station was there. They wanted to add a convenience store. That's pretty common anywhere. But the convenience store required a special permit. The planning board granted the site plan application, but the city council, so the legislative board, the political board, the elected board, was the board that was designated to grant the special permit or consider the special permit application. And in this instance, the city council denied the application, emphasizing the community opposition. And so the court made clear what the standard is for a special use permit. Unlike a use variance, a special use permit does not entail a use of the property forbidden in the zoning ordinance, but instead constitutes a recognition of a use which the ordinance permits under stated conditions. So a special permit use is a use that has already been identified as being in harmony with the zoning district in which it's located in. So the only thing that an applicant would have to demonstrate is that they comply with the code's conditions as to when that use can operate. And it's certainly much lighter than the standard for a variance, especially a use variance, but we'll get to that later. So once compliance with these conditions in the code have been satisfied, and I can't tell you exactly what they were, because it's up to the legislative board in adopting their code provisions to determine what those conditions would be, what's appropriate based upon the zoning district, the use, and the specific needs of that community. So once the conditions have been determined to be satisfied, the permit must be granted unless there are reasonable grounds for denial supported by substantial evidence. And denial cannot be based on community opposition. This comes up again and again. In this case, the court held the city council did not have a rational basis for denying the special permit because there was no evidence establishing that there would be a detrimental effect on the health, safety, and welfare of the neighborhood from granting the application for the convenience store. So the applicant had demonstrated compliance with the conditions. The city council denied the application, and there was no basis in the record to justify why they did it. And I have in my notes record with like 5 exclamation points, because I can't emphasize that enough, and you'll hear me say it over and over again throughout this talk. But it's so important to make your record, because that's what the court is going to be looking at when they make the determination, and it cannot just be based on community opposition. And if it is based on community opposition, it needs to be substantiated by something. But just saying, I think it's going to create more traffic, I don't want people double parked in front of my house, unless there's actually a basis to think that's going to happen, then it's probably not going to be enough. So the next case is McGinn versus Zoning Board of Appeals of the Town of East Hampton. So petitioners in this case had made an application for a natural resources special permit. And this is a special permit, we're talking the South Fork of Long Island. So a lot of waterfront property. And in this case, the natural resources special permit was so that this property owner could construct a dock on their waterfront property. And the zoning board denied the special permit. The court acknowledged that local zoning boards have broad discretion in considering variance applications. Variance, that's the key distinction. And judicial review is limited to determining whether the action taken was illegal, arbitrary, or abuse of discretion. However, this was not a variance application, it's a special permit application. Like we saw in the other case, it was decided by the city council, right? So that deference that's afforded to zoning boards in their variance, in their appellate variance capacity, doesn't necessarily apply to a special use permit, because again, you're basing it on the statutory conditions in your code, and it's not specific to a zoning board. It could be a zoning board granting the special permit, or it could be, like we said, the city council, town board, board of trustees, planning board. Any board could really be designated however that local municipality prefers in their code. So because this was a special permit, again, it gives permission to use the property in a way that's consistent with the zoning, but not allowed as of right, because you have to demonstrate compliance with the conditions. So petitioners here, the dispute was, did the petitioners satisfy the conditions? Petitioners obviously say yes, they're the property owners, they want the dock. The town, the zoning board said no. And the court agreed with the petitioners. And the court actually looked at the code, looked at the specific conditions that the zoning board claimed had not been satisfied, and then looked at the record and said, well, no, they did satisfy them. Look, here's where. And so the first issue was that the code required that the dock be removed seasonally, but it did allow an elevated fixed walkway, referred to colloquially as a catwalk, to remain in the water permanently to maintain a floating dock. And petitioners designed it exactly that way. They proposed the fixed catwalk, but agreed to remove the ramp and the floating dock during the winter months. So the court said, no, they did satisfy this condition. I think the distinction was because the catwalk was going to remain in the water, but the code did actually permit that if you kept reading through the rest of that provision. Further, the code required to explore alternatives. So is this necessary? Is there any other way, any other reasonable way that the applicant can safely access and utilize a boat without having to put a dock here? And the petitioner showed that they did explore that. They considered the suggestions that the zoning board had actually presented to them, and none of them were really feasible. There was the suggestion of a pulley and mooring system, but they determined that would be a safety hazard for children. If you could put the dock in a different location in the middle of the property as opposed to on one of the ends closer presumably to the neighbors, it would result in a shorter dock, but the water was so much more shallow that the boat wouldn't be able to maneuver in during low tide. While the town or the ZBA disputed those issues factually, there was nothing that the zoning board could point to in the record to show that there was a basis for them to disagree with it at the time they issued their decision. Again, the record. So if you're going to deny a special permit, you need to have substantial record evidence in the record to justify it. Failure to comply with the conditions is a justifiable basis for denial, but the record and the board's determination should show how the conditions were not satisfied so that it's easier for the court to see your position if and when you end up there. Area variances. Hampton's Residence LLC versus Village of East Hampton. So the zoning board denied petitioners' request for area variances to construct an enclosed gazebo on their property. And now, again, like I referred to during the special permit discussion, the court acknowledged that the deference that's afforded to zoning boards in considering variance applications, and the determination should be upheld as long as it's not illegal, it has a rational basis, and it's not arbitrary and capricious. And the criteria and the standards for review for an area variance are set forth it's pretty much the same criteria, the same standard. It's set forth in state law, in New York town law, in New York village law, and in New York general city law. So it encompasses pretty much all of the local municipalities that would be affected in our area. And so what the ZBA is required to do in considering an area variance is engage in a balancing test, weighing the benefit to the applicant if the variance is granted against the detriment to the health, safety, and welfare of the neighborhood or community by such grant. And then there are the 5 factors that the zoning board is supposed to consider in engaging in that balancing test. Whether an undesirable change will be produced in the character of the neighborhood or a detriment to nearby properties will be created by granting the variance. Whether the benefits sought by the applicant can be achieved by some method feasible for the applicant to pursue other than an area variance. Whether the requested area variance is substantial. Whether the proposed variance will have an adverse effect or impact on the physical or environmental conditions of the neighborhood or district, and whether the difficulty is self-created. And in this case, the court upheld the denial, finding the zoning board properly applied the balancing test and factors, in concluding there would be an undesirable change to the character of the neighborhood, the variances were substantial, and the hardship was self-created. And the court also noted that in applying the balancing test, the zoning board was not required to justify its determination with supporting evidence for each of the 5 statutory factors, as long as they could show they engaged in the balancing test and that the determination is rational. And I'm going to say that may be fine. The court may say that, and I've seen that language several times. I believe that that's the standard they hold it to, but I suggest that you try to justify it based upon every one of those factors. Because if you leave one out and then it ends up before the court and the court's looking at the record itself, it may say, well, you didn't address whether there's a feasible alternative. And here they say there isn't a feasible alternative, so you want to cover all your bases so that you don't leave it open for someone reviewing it in the future to be able to interject their own opinion, even though the courts aren't supposed to. But we're going to see in the next case right now that that's not always how it goes. William versus Town of Lake Luzerne Zoning Board of Appeals. Like in the previous case, here the zoning board denied petitioner's application for area variances to construct a garage that exceeded the permitted height. So in this case, this is kind of an interesting fact pattern. The petitioner had acquired 2 adjoining lots at different points in time. I think the first lot in 2012, and then they acquired the second lot in 2018. But they were abutting lots; they were right next to each other, and they both had single-family homes. One of the single-family homes was very dilapidated, so the petitioner went to the town, following the rules, got a demolition permit, and demolished the dilapidated single-family home. And then she stopped following the rules. And she, without going back to the town, without getting a permit, without getting a building permit, she constructed a 3-car metal garage in the place of this single-family home that had been demolished, presumably to service the single-family home that was still existing on the neighboring lot. But again, she did not get a permit for that. And if she had gone to the town, they would have said, you can't have an accessory structure on a lot without a principal use. So you couldn't just have a garage as an accessory use to a single family home in that zoning district. You couldn't just have a garage on that lot without having a principal use of the single family home as well. But like many building inspectors and code enforcement officers do, they try to help their constituents. And so what the code enforcement officer in this case said was, if you merge these 2 lots, then you can have the garage that is servicing an accessory to the single family home. And she said, wow, that's a great idea. So by deed, she merged the lots. I guess in this town that they do it that way. Some towns will not let you just merge it by deed. You may have to go for a lot line adjustment, or some call it a re-subdivision. Look at it, you Haverstraw, and so you would have to go through basically the subdivision process, where you're merging the lots instead of the standard subdivision concept of separating them. So she did that, but there was still an issue. And the issue was that the garage's height did not comply with the code regulations. It's not that it was too tall. It was that the code said that the accessory structure could not be taller than the principal structure. And in this case, the principal structure, the existing single family home, was roughly 14 feet. And the garage that she had constructed was approximately 18 feet. Now, they were both well under the height limitation, but the issue was because the height of the garage was taller than the height of the single family home. So she goes to the zoning board for her variance, and they say no. So now, she has this garage that she constructed, rightfully or wrongfully. She didn't have a permit when she did it, but now basically they haven't granted the variance. So what are her options? Her options are either to make her house taller or make her garage smaller. So she decides, I'm going to go to court instead. And the court helps her out, because the zoning board made its record. It said that it would not be in character with the neighborhood. It would be a detriment to the community. The petitioner did not address other feasible alternatives because she had already constructed it, and that the hardship was self-created. And again, we're talking about a standard where the court is looking at this and should just be looking at it with deference and saying, is there a rational basis for this? Is this arbitrary and capricious? That is not what the court did here. The court basically became the zoning board. And the court acknowledged the deferential standard, but then engaged in its own analysis. So, and in doing so, pretty much criticized the ZBA's rationale on virtually every finding. So the court found that in concluding the garage was inconsistent with the character of the neighborhood, because the garage was higher than the principal structure. The court said, well, if the fact that something doesn't comply with the requirements of the zoning code means that it's not consistent with the character of the neighborhood, then no variance application would ever be consistent with the character of the neighborhood, which is actually an interesting argument and one I hadn't really thought of. But so basically what the court is saying is, if you're saying it's not consistent with the character of the neighborhood because it doesn't comply with zoning code, then you're kind of turning the analysis on its head, because then you could never satisfy that standard anytime you go in for a variance. The court did note that both the residence and the garage were under the height limitations of the code. And one thing that the court did point out that it found significant was that the dilapidated single family home that had been demolished was actually taller than the garage that replaced it. And that single family home was a permitted use, and it had existed for a long time, because again, these structures didn't exceed the height limitations. It was the relationship between the heights of the two buildings. The zoning board did make a point of the fact that the garage was steel, but it didn't explain why this was an issue, or indicate that steel wasn't permitted as a material to be used. And the zoning board had made an affirmative determination that there would be no negative environmental impact from the garage. In addition, we had neighbors, the public hearing, the zoning board had neighbors come out and say, we really don't mind this garage. The house that was there before, it was such an eyesore. It was in such bad shape. She did us a favor by taking it down. She put up this nice new building. It's one lot now. It doesn't look bad. There was one person who opposed the application, but for the most part, the other neighbors were satisfied with it. The court did acknowledge it was hard to address the feasible alternatives because the garage had already been constructed. And the court also acknowledged the hardship was self-created because she built it without a permit. But the court cited to the statutory language that was not cited to in the previous case, which is an important caveat as it relates to the self-created hardship criteria in an area variance, which states that while the fact that the hardship is self-created is relevant, this does not necessarily preclude the granting of the area variance. So the fact that it's self-created is not determinative, and the legislature found it significant enough to put in the statute itself that to make that very clear, to anyone who is reading these provisions. And then lastly, the court said, well, you know, it's 4 feet. That's a variance of 29%. I guess 29% could be pretty substantial, but how is it really going to have a negative impact? The garage is smaller than it was. The residents liked it. So I was very surprised by this decision because the court really took a lot of leeway in going through this analysis. Maybe he was sympathetic to the petitioner. I really don't know, but I'm surprised that the court went through this level of analysis. And basically, if you think about what I was saying, the court acknowledged that there was no alternate, that, they didn't discuss feasible alternatives because it was already constructed. It was substantial in number, and it was a self-created hardship, but then ultimately still ended up saying, and the zoning board was wrong, the variance should have been granted, so I'm overturning this decision. So you never know what a court's going to do. You don't know how interested they're going to be, or, whether they're going to try to, they're not supposed to inject their own opinions. They're just supposed to make sure the zoning board did their job. Same thing with planning boards, but some courts treat things differently, and you never know who you're going to get. So that's why I just keep coming back to make your record, justify your decision to the best of your ability, so that you don't leave anything in the court's hands, or any openings where a different interpretation or a different result can be inferred. Use variances. We actually have a lot of use variances cases this time, which I kind of like, because they generally have interesting facts, and I guess I'm a dork. 790 Holdings Court versus Board of Appeals of Town of Hempstead. Petitioners applied for a use variance to operate a used car sales showroom and lot. The zoning board denied the use variance, and the petitioners appealed to court. So this case is quick, just to go over the criteria for use variance. It differs from an area variance in two very important ways. Well, in many ways, but whereas the area variance standard is a balancing test, you don't have to satisfy all of the factors in order to come out one way or the other. For use variance, you absolutely have to satisfy all of the criteria. If you don't satisfy one, then like we're going to see in this case, then there's no way you're going to get the variance. The other distinction is as it relates to self-created hardship, which is a factor in both area variance and use variance. And while an area variance has that qualifying language I talked about earlier, where it's relevant but not determinative to the decision whether to grant the use variance, there's no such qualifying language as it relates to use variance. So if it's determined to be self-created in a use variance, that's another basis in which you're automatically not going to get the relief you're seeking. So in this case, the court did uphold the denial of the, I didn't actually say what the criteria was. So you have to demonstrate an unnecessary hardship by showing the property cannot yield a reasonable return if used only for permitted purposes as currently zoned. The hardship resulted from unique characteristics of the property. The proposed use would not alter the character of the neighborhood, and the alleged hardship is not self-created. So those are the 4 criteria that have to be established in order to be able to justify a use variance, because what you're asking for is authority to use property for a purpose that's not permitted in that zoning district. So if it was a light standard, then everyone would do it, and use regulations would, be rendered meaningless to a certain extent. And in this case, the court did uphold the denial of the use variance because petitioners could not satisfy the first condition, which is demonstrating by competent financial evidence, which is dollars and cents proof, that they cannot yield a reasonable rate of return on the property under the current zoning. And because they couldn't satisfy that factor, the court didn't even address the remaining factors, because again, you have to satisfy all of them. And this is a very dense requirement. You have to competent financial evidence, dollars and cents proof, and reasonable rate of return, right? Not the highest and best rate of return. You're not entitled to a windfall. You're entitled to a reasonable rate of return under the current zoning. So any other use that's permitted in that zoning district, you have to demonstrate that you cannot earn a reasonable rate of return from those uses. And this has to be demonstrated by competent financial evidence, dollars and cents proof, not just saying it would be too hard or it would be a big investment. You have to actually show why you can't do it. And it's generally a very hard thing to do. And that's why a lot of people, in lieu of seeking a use variance, they will seek a zone change instead from the legislative board, because there's more flexibility there rather than these factors to be considered. 80 Woodland Avenue LLC versus Village of Catskill. A petitioner purchased a former school consisting of 3 buildings that are zoned for single-family residences, and there's also limited development restrictions given its proximity to the Hudson River. A petitioner applied to convert the 3 buildings to 43 multifamily apartments. A use variance was required because it was in a single-family residential district. And while single-family homes were permitted, so residential was permitted, multifamily was not. And the zoning board denied this use variance as well. So like with the previous case, most often the use variance is denied for failure to demonstrate reasonable rate of return by dollars and cents proof. But here, the zoning board looked at different factors for the basis for the denial. It was the 3rd and 4th factors, which is that the project would affect the essential character of the neighborhood and that the difficulty was self-created, respectively. So with respect to the self-created hardship factor, again, we can't give the benefit of, well, even if it is self-created, it doesn't preclude granting the variance, the use variance. That's not the standard for use variance, and you don't get that luxury when you're seeking use variance. So with respect to the 3rd factor, the impact on the character of the neighborhood, the court acknowledged the deference to the zoning board, saying that this determination, the impacts to the neighborhood, is best left to the local officials who possess the familiarity with local conditions necessary to make the often sensitive planning decisions which affect the development in their community. So the court's saying, you local residents who have been living in this community for a long time, you know better than me, the court, what the neighborhood is and how putting 43 residential units on this property is going to impact it better than the court would. So in this case, the zoning board's rationale was that the surrounding neighborhood was single-family homes. The zoning board also believed that there would be an increase in traffic from the conversion of this vacant parcel with the three vacant structures to multifamily homes. The applicant tried to address this, and they actually, I thought they did a pretty good job. They provided expert testimony saying that, well, wait, these aren't just vacant structures. Remember, this used to be a school. And here's our analysis, here's our traffic analysis of what the traffic was when this was a school and what it would be for the 43 residential units. And look, at the AM, PM peak times in the morning and the evening, when most people are traveling, it's pretty much the same. So it's really not an increase in traffic over what was there previously. The zoning board did not have any expert evidence to the contrary. The neighbors did not provide any expert evidence to the contrary. So it really seemed like the applicant was on good footing with that. But the problem was that the school ceased operating in 2006. And now the court's making this decision in 2025. So we're talking close to 20 years. And during that time, there was a brief stint where I think it was used for temporary offices. But other than that, these have been vacant. So really the status quo for decades, more than a decade, has been that there's been no traffic generated from this parcel, especially related to a more high intensity use like a school. Not that an increase in traffic is a basis not to allow development. But when you're asking to do something that's not permitted by the zoning code, then you have to demonstrate that it's not going to negatively impact the neighborhood. And here the court said, well, it really would, because it's been vacant for so long. And with a school, people come in the morning and they leave in the afternoon, right? And during the day, they're there for the most part. You're teaching, you drop your kid off, you pick them up. Whereas with residential units, people are coming and going at all hours of the day. So while the AM and PM peak times may be the same, the additional traffic in between those hours and earlier in the morning and later at night would be an additional traffic impact above and beyond what it was when it was a school. So the court found that, based upon the deference afforded to the zoning board and their unique knowledge of that area, that they did, that the zoning board was correct in finding that the use variance did not satisfy the third factor. And then with respect to the self-created hardship, the court explained a hardship will be considered self-imposed when the applicant for the variance acquired the property subject to the restriction and was aware of the restriction at the time of purchase. And the court made a distinction where the hardship may not be self-created if the owner purchases the property for a different purpose, but that purpose becomes obsolete over time. So, you know, if you bought something, a property, I don't know, mining or something, right? You know, something that's outdated, and then you want to convert it, but the zoning hasn't really caught up with what is feasible. Or maybe even like a strip mall or something, something where a lot of people are shopping online. It's not necessarily feasible to do, or, it might not be cost effective to do something like that. So you want to do something that's actually going to be functional in the community, but it's not allowed. So that was the example that the court gave as a situation where it might not be self-created. But here the court said it was self-created because petitioner knew the zoning restrictions when they purchased the property, and the only change in circumstance was that they realized it wouldn't be profitable to develop the property in a manner that was permitted by the zoning code. And the court concluded that although the purchase may now be viewed as a poor investment, courts are not responsible for guaranteeing the investments of careless land buyers. So the court really had very little sympathy for this petitioner. They knew what they were getting themselves into, and they were just trying to, maximize, from the court's perspective, maximize their profits. It had been vacant for a long time for a reason, because it was hard to develop because of those restrictions on it. And so the court wasn't really going to bend over backwards for them. And then the last, sorry.
I was just going to interrupt to do another attorney affirmation code word. So all attorneys out there, get your pen and paper ready. The second code word we'll be doing tonight is general. Before he was president, Dwight Eisenhower was a general. So that's the second code word. And if you don't mind, Christie, I was just curious about the dollars and cents proof factor. Have the courts made a basic distinction between like the profitability of using a site for perhaps a business, or between that and just selling it, developing it, selling it like a residential property?
I think they're looking at the use, right? Okay. Because if it's a use variance, like you're seeking to vary the use of the property, it could be that there's a sale that's contingent upon getting that use variance. But the standard is can you do anything else with this property and earn a reasonable rate of return based upon what's permitted under the current zoning? That's what you have to compare it to.
Okay. I was just wondering because it seemed like, one thing was, like the difference between operating a business and then developing and selling a piece of property. I was just curious if there had been any distinctions made between those two.
I mean, the board could ask, what do you intend to do with this?
Yeah.
But you know, for residential multifamily, you know, they're either going to sell them off or they're going to rent them. But I don't know that that would necessarily be relevant, and I don't know that the developer or the owner would necessarily tell the truth.
Okay. I was just curious. Thank you.
So the last issue petitioner made was that he felt he was prejudiced because one of the board members didn't think they were allowed to vote on the application. They didn't say why, but it seemed like they may have thought there was a conflict that didn't exist or something like that. And the court said, no, that's, you know, you still had a majority of the entire complement of the board, 3 out of the 5 members, who voted against you. So even if this person had voted, you still wouldn't have gotten your variance. So there's no change. There's no prejudice there. Franklin Square Realty Associates versus Board of Appeals of the Town of Hempstead. So petitioner owned split property between 2 residential zoning districts and sought to construct a self-storage facility on them. The building department determined a use variance was required, and petitioner appealed that determination to the zoning board. So appealed the determination, didn't seek a use variance, appealed the determination to the zoning board on the grounds that a use variance was not necessary because they had already got, the property had already been granted a use variance back in 1959. The zoning board disagreed with petitioner's interpretation that they did not need a use variance, and so petitioner brought an Article 78 in court. So in the course of the zoning board reviewing this application, the zoning board actually determined that the 1959 variance was improperly granted because the applicant had not satisfied the standard for use variance that was in place in 1959. And in court, the petitioner goes, whoa, you know, you can't do that. It was granted in 1959. We're talking about, you know, 2015, 2020. You can't go back in time. And the court said, well, actually, the zoning board can, because you were the one that brought it to their attention. And so it was put back before them. And there's a very, very favorable concept as it relates to municipalities, where a municipality is not stopped from correcting an error. And so the court said, you know, when the zoning board took another look at this, because you brought it to them, they saw it wasn't properly granted, and so they decided that it didn't carry any weight, and so you can't rely on that anymore. But even if the 1959 use variance was still valid, the use variance was only for one specific unauthorized use. It's for the use that you present to the zoning board with all of the standards that you have to satisfy, right? Because remember, the dollars and cents proof element, you're looking at that specific use compared to all the other uses that are permitted in the zoning district, how that use affects the character of the neighborhood. So it's a very fact-specific inquiry for a use variance based upon that specific use you're proposing. So it's not a zone change. It's not a zone text amendment where you could say, well, I got a use variance for commercial, so now I can do anything commercial. It's like, no, if you got a use variance for an office building, you can't then say, well, I have a use variance for an office building, so now I can do self-storage. That's not how it works. So again, I started off with this, but petitioner did not seek a use variance, right? So the building inspector said, you need a use variance. Petitioner appealed that determination for an interpretation from the zoning board. What they could have done was alternatively said, okay, well, zoning board, we don't think we need a use variance, but if you disagree with us, here's our use variance application. That's something that happens very frequently to cover all of your bases, because technically under state law, you're supposed to bring an appeal within 60 days of the building inspector's determination. They didn't do that. Perhaps it was because they felt they were on such strong footing with the 1959 use variance, or perhaps it was because they knew they weren't going to be able to satisfy the criteria for an area for use variance today anyway. I don't know why, but I thought that was interesting. Freepoint Solar LLC versus Town of Athens, Zoning Board of Appeals. Petitioner proposed constructing a new solar energy generation facility in a rural residential zoning district but the zoning code expressly prohibits solar facilities in all districts except certain commercial and industrial districts. So petitioner sought what's called a public utility use variance, which the ZBA denied. Petitioner appealed this to court, arguing that the zoning board did not apply the correct standard because they applied the general use variance standard as opposed to the public necessity use variance standard, which is what's utilized for when you're developing public utility infrastructure, and which is a lower burden of proof than the standard use variance we've been talking about. The court said, it has long been held that a zoning board may not exclude a utility from a community where the utility has shown a need for its facilities. So in this case, the standard for a use variance for a public utility infrastructure is to show that siting or modification of a utility facility is a public necessity in that it is required to render safe and adequate service, and that there are compelling reasons, economic or otherwise, which make it more feasible to grant a use variance than to use alternative sources of power, such as may be provided by other facilities. So you're looking at a public necessity standpoint. Do we need this? Is this going to service the community? And then there's also this kind of sliding scale as to the degree of the intrusion on the community or burden on the community. So where the intrusion or the burden on the community is minimal, the showing of public necessity that's required by the utility should be correspondingly reduced. The lower the impact from the utility, the lower the standard the utility has to establish. Because the impacts from the solar facility were minimal, the zoning board should have reduced the petitioner's burden, but they didn't. And while the zoning board tried to justify themselves to the court wouldn't consider their arguments because they weren't in the record before when the application was before the zoning board. They came up with new arguments after the fact that they hadn't used when they were hearing the application in order to justify the denial. And the court said, well, if that wasn't your basis then I'm not going to entertain it as your basis now. So again, the record. And so then the court really gave us a good deep dive into what constitutes public necessity. And it said, you have to look at the big picture. While there are some local considerations like aesthetics and environmental impact, those were addressed during the seeker review. The public necessity analysis is a broader consideration. The court looked at the state's objectives in transitioning to renewable energy as a benefit to the public at large and found that this project was in line with that goal. The zoning board's argument that the state could achieve the goal without this project was rejected by the court because the court said, you're focusing on floors rather than ceilings. You know, we're trying to do the best we can, not the bare minimum. And that this project was consistent with the state's future long-term goals and targets. So it should have been given pretty high consideration in this public necessity concept. And the court rejected the zoning board's argument that petitioner couldn't demonstrate it would be impossible to construct the project in a zoning compliant district. Remember, this solar array was permitted in certain districts, but only in commercial and industrial areas. And the court said, no, there's no legal requirement that in order to build a public utility like a solar array, you have to demonstrate that it can't be built anywhere else. That would be untenable. It would make these types of projects cost prohibitive, and that's not the standard. Interpretation, legal nonconforming use. Tiekert versus Board of Appeals of the Village of Mamaroneck. I was actually handling another application before the Zoning Board of Mamaroneck when this application was before them. They had a lot of long meetings discussing this one. So petitioner owned the condominium on the second and third floors of a 3-unit complex. And he got a violation saying that he was illegally renting out a second unit in his condominium because he converted the third story to a separate unit. He appealed that violation to the zoning board, which he could do because it was a determination as it relates to the zoning code. The court acknowledged that the general rule is that a zoning board's interpretation of its zoning ordinance is entitled to great deference. So now we're talking about the zoning board's interpretation of its code, great deference. However, there is a narrow but well-recognized exception to this rule, where the question is one of pure legal interpretation of statutory terms, in which case deference to the zoning board is not required. Here, the court found it was a pure legal interpretation of statutory terms, and therefore it was not required to give any deference to the zoning board. Further, the court acknowledged a pretty long-standing zoning principle, and very prevalent, which is that a zoning ordinance must be strictly construed in favor of the property owner and against the municipality which adopted and seeks to enforce it. Any ambiguities must be resolved in favor of the property owner. And this is because zoning laws are in derogation of private property rights. So if there's a reasonable interpretation of the code that favors the property owner or is more beneficial to the property owner, then that's the interpretation that should be applied. So the court looked at the actual language of the code, which stated, and basically how they defined what a dwelling was. I remember that the building inspector's interpretation was that he had illegally converted his condominium into 2 separate units. So the code said that dwelling units may not share enclosed spaces other than vestibules, entrances, hallways, or porches. And the code further stated that a dwelling unit is defined as having complete housekeeping facilities. In this case, the area that was being rented out didn't have an oven or a stove, which the court interpreted to be housekeeping facilities. So ultimately, because the way this extra area that was being rented was laid out, it didn't comply with the definitions of the code for a dwelling unit. The court determined it was not a separate dwelling unit, and therefore the petitioner was not in violation of the code because he had not created a separate unit. I find this decision confusing for 2 reasons. The first is because the court said no deference was required to the zoning board's interpretation because it was a pure legal interpretation of statutory terms. But then the court applied very specific facts from the zoning board record to the statutory language in reaching its decision. So it's not really a strict statutory interpretation as far as I could tell. And I've seen a lot of cases like this where they say it's not entitled to deference, but then, you know, all these facts are coming out that were part of the zoning board's record. So I can never really tell how the courts reached that decision. But in this case, it seemed to me like it was a pretty factual determination because you had to look at how the unit was configured and the specifics of the design and apply that to pretty clear language in the zoning code that didn't really require much interpretation. And the other thing that I found interesting was that the court found it wasn't a separate dwelling unit because the unit didn't satisfy the requirements of the code to be a separate unit. But that could have just meant that it was a separate dwelling unit that didn't comply with the code, which could have resulted in more violations. But the zoning board and the court didn't go that route. So I guess it was basically because they were starting off from the point of the building inspector, which was that the assumption that it had been converted to a separate unit. Then the next case is Smith versus Town of Thompson Planning Board. The planning board approved a site plan and special permit for a 560,000 square foot mixed use facility. And the facility was inconsistently described by the applicant during the application process. A warehouse was a permitted use, but a distribution facility wasn't. But the applicant described it as a warehouse/distribution center. And so after they got their approvals, the neighbors challenged whether this was a permitted use. And under state law, in this case, it would be New York town law, it's the zoning board's role to make interpretations as it relates to the local zoning code. But the zoning board's jurisdiction is appellate only. Things don't come to them unless it's referred by someone with authority to do so. So there must be a determination by the local administrative official, most often the building inspector or code enforcement officer, that's appealed to the ZBA. The court found here that there was enough ambiguity as to whether the use was permitted that a determination should have been made. And that determination was made, but it was made by the planning board in the context of the site plan and special permit application, which the court found to be improper because the zoning board has that authority, but the planning board does not have the authority to interpret the zoning code or determine what uses are permitted under the zoning code. So they said what the planning board should have done is either sent it to the building inspector to make a determination or referred it to the zoning board themselves. That did not happen. And so the court actually invalidated the approvals for this huge project, 560,000 square foot project, to send it back to the municipality for a determination from the appropriate board, well, or person, whether they start with the building department or the zoning board, to determine whether the use is permitted. If it wasn't permitted, then they would need a use variance as opposed to a special permit, and then you're looking at a completely different project. Zoning and Legislative Acts, PF Development Group LLC versus Town of Brunswick. Plaintiffs owned multiple parcels that spanned several zoning districts, including a commercial district and 2 different residential districts. One of the residential districts is the R25, and that's important because that's going to come back. So in 2016, the planning board conditionally approved the site plan approval for the parcel that's in the commercial district for several commercial establishments, a gym, fast food, supermarket, so big retail. They were going to be national name chains. But at the time, they weren't proposing anything for the residentially zoned parcels. In 2017, after the planning board had granted the approval for the commercial development, the town board adopted a local law that allowed multifamily residential in the R25, which part of this property was located in, with a special permit. The plaintiffs got really, really excited because now they were able to envision a much larger scale mixed-use development than they were previously when they had the commercial portion and then they had the single-family residential. Now it opened up different opportunities for multifamily residential as well, where you could have a mixed-use type development. So they completely redid their plan. They came up with this big master plan that included the commercial development as well as the multifamily development on the R25 parcel. During the time that it was before the planning board, which is quite a while, the planning board repeatedly expressed concern about this local law the town board had adopted and whether the town was already saturated with multifamily housing. There was also questionable conduct and statements being made by the planning board chair, who happened to own the land adjacent to the proposed apartment building. And they don't get into the specifics, but you can discern that he probably made comments that he wasn't happy about this development. And ultimately, the chair did end up recusing himself from the application about 10 months after it came back. So the planning board issued a positive declaration under SECR, which we'll talk about later, that required the preparation of an environmental impact statement. And by November 2019, so this was 2 years after they submitted the master plan, they were getting frustrated with how long the process was taking. And the town pretty much said to them, look, if you want to move forward, if you want to get your approvals in a timely manner, you gotta get rid of the multifamily component of this. Just go forward with the commercial that you had before and you'll get your approvals. And they did so under protest, but they needed to get going, and it seemed like the multifamily was the portion that was holding them up. So under protest and with preservation of rights, they withdrew the multifamily portion and they got their approvals. The town board put a moratorium on multifamily land use, and in December of 2022, they adopted another local law specifically to regulate the location and density of 2-family and multifamily dwellings. And they put more stringent density requirements and steep slope restrictions on multifamily housing in the R25 zoning district. So it was pretty clear to anyone watching what was happening that this was a direct response to what the petitioner was proposing. So they brought a litigation raising two issues. The first was that the local law constituted reverse spot zoning. So you may be familiar with spot zoning. We've talked about that before, which is when one parcel is singled out for favorable treatment. Reverse spot zoning is where one parcel is singled out for unfavorable or more restrictive treatment. So to establish reverse spot zoning, two elements have to be proven. First, there has to be a showing that the zoning was site-specific, meaning it only applied to a plaintiff's property. And in this case, the court couldn't say definitively that it wasn't. They said it was an issue of fact and that it couldn't be decided on this record. But the second element that had to be proven was that the local law was not consistent with the town's comprehensive plan. So remember, when someone's analyzing whether something could potentially be spot zoning, you want to look and make sure it is consistent with the comprehensive plan to show it isn't spot zoning. Here, to show that it isn't reverse spot zoning, again, you show it's consistent with the comprehensive plan. And that's what the town was able to do as a matter of law, as the court found it, that they were able to determine that because this local law was consistent with the comprehensive plan, that it could not be reverse spot zoning, and therefore that claim failed. But there was also this claim about the alleged actions and bias of the planning board chair during these proceedings, both before and after he recused himself from the application. At this point, they were just allegations. Nothing had been proven, but the petitioner did claim that even after the chair recused himself, he was still kind of pulling the strings behind the scenes, so to speak. And prior to recusing himself, the question was, you know, what kind of influence had he had on the remainder of the board in their analysis of the project and of the local law that the town board ultimately adopted. And the court starts off by saying, you know, he's not on the town board. The town board is a separate entity that is a legislative elected board, and they're the ones that adopted this local law. But the planning board under the code, and this is common in many municipal codes, if you're considering a zone text amendment, the planning board will provide a review and recommendation and referral to review and recommendation to the legislative board on their thoughts regarding the local law. And that's what the planning board did. So basically what the court said was, you know, these are just allegations now about the bias and the behavior, but if it's true, then it is possible that the planning board was influenced by it. The planning board could have been influenced in the referral and recommendation they sent to the town board, and then the town board could have been influenced by it, how they received the planning board's memo, and how they ultimately ended up adopting another local law, changing the regulations from what they had adopted a few years earlier, which were much more flexible and trying to incorporate more multifamily housing. So basically, the court said, you know, we're able to decide the reverse spot zoning issue now because we can do it on the law because there are no disputed facts. Here, we need a greater analysis of the facts in order to assess whether there was any sort of impropriety that occurred here. And we can't do that on this record. So for the lower court to have dismissed the petition was premature. And so the court remanded the issue to the lower court to explore these allegations as to bias. So, you know, I don't know that you know, they're just allegations in the complaint. And I always try to say this to you guys. I'm only telling you what I read. I don't know if any of this is true, but it was something that the court found warranted further investigation. But, you know, you all live in these communities and you volunteer and you provide your time. And, you know, it's impossible to think that there might not be some project that's close to your house or, you know, will affect you. And you just have to be cognizant of that. And Only you can decide if you have a conflict, but the goal is to avoid the appearance of impropriety. And so if you're ever not sure, talk to your municipal attorney, talk to your chair, but you have to be able to be objective, and only you can answer that question. Code enforcement, McWhinney versus Rockland Cider Works. So 13 resident taxpayers brought an action pursuant to Town Law Section 268 to enjoin another property owner from operating a cider manufacturing and bar service business on the grounds that the use violated the town zoning code. They sought an injunction to prevent the operation of this business. The town moved to dismiss the action, but the property owner sought to dismiss the action, but the court refused to do so and upheld the injunction prohibiting the use. So under what authority do taxpayers just have the ability to go and start suing property owners to stop them from violating the zoning code? It's under Town Law Section 268, which allows the town to bring an action to prohibit unauthorized activity on a property. So if it violates the zoning code. And upon the failure or refusal of the town to do so, within 10 days of written request by a resident taxpayer, any 3 taxpayers aggrieved by the violation may do so in the same manner as the municipal official authorized to do so. So basically, if you have a taxpayer who says, hey, town, they're not supposed to be doing this. You should stop them. Don't let them do this. And, 10 days goes by and the town doesn't stop them, then you can get 3 taxpayers and they have to be aggrieved by the violation, right? So we're going to talk about standing in a little bit. Can't be someone who lives on the other side of town or 2 towns over. They would have to be aggrieved. So they would have to demonstrate some sort of harm from these operations. But then these 3 taxpayers, in this case there were 13, can step into the shoes of the town and bring an action to enforce the zoning code in the same manner that the town would have been able to. And so that's what they did here. And so the court noted that the taxpayers satisfied the condition precedent to bringing a Town Law Section 268 claim by, quote, establishing the town's official lassitude or nonfeasance in the enforcement of zoning laws. Essentially, the taxpayers had to allege, again, these are allegations, start of litigation, so it's just one of the conditions precedent to bringing the litigation, that the town wasn't enforcing the zoning code, so the taxpayers had the right to do it instead. Whether that will end up being the case at the end of the litigation, I don't know. And there's a lot of reasons why a municipality wouldn't want to shut down a business in 10 days. You have to weigh a lot of factors, a lot of interests in deciding what to do. Generally, you try to work out some sort of resolution and, maybe not make everyone happy, but, keep your businesses operating, keep your residents and your taxpayers from having to deal with potentially noise issues, traffic, stuff like that. I don't know what the issue was here. But, I kind of think it's better to have a provision like this because if you have residents that are that committed to going that route, then let them do it. Eminent domain, JHK Development LLC versus the town of Salina. The town board sought to take a half-acre of property by eminent domain to create an access road for the proposed private redevelopment of a dilapidated and vacant factory. The property was to be redeveloped with, among other things, a new athletic facility. The owner of the land was being taken by the owner of the land, which was being taken by eminent domain, challenged the eminent domain action. So the law, as quoted by the court, the power of eminent domain, the right to take private property for a public use, is an inherent and unlimited attribute of sovereignty, whose exercise may be governed by the legislature within constitutional limitations and by the legislature with its power delegated to the municipalities. So the courts recognize that there's a longstanding policy of being able to utilize eminent domain for a public benefit. And there's considerable deference afforded to these municipalities in making that determination. and a court cannot substitute its judgment for the municipality as to whether there's a public purpose. So the burden is on the person challenging the eminent domain in order to establish the condemnation is without foundation and baseless. So here, the property owner said, well, this isn't a public use because it's for private property. You're taking this and you're giving it to this private developer who's, going to create a sports facility. Like, what's that? Why do they get half an acre of my property for that? And the court said, well, you know what? It is a public purpose because it's supporting the redevelopment of a dilapidated factory, and it serves the purpose of renewal. You'll have better infrastructure. You'll have, a sports facility for the community. You'll have more tax revenue. You won't have these dilapidated buildings that are dangerous and a hazard. And the court said economic underdevelopment and stagnation are threats to the public sufficient to make their removal cognizable as a public purpose. So just because it was a private entity that's developing it, that doesn't necessarily mean that there isn't a legitimate public use or purpose associated with it that would justify eminent domain. And the court was also unfazed by the fact that the private developer and the municipality were, quote, working together on the matter because private-public partnerships aren't unheard of, and the objective was to foster redevelopment for urban renewal purposes. And as it related to the prior public use doctrine, the petitioner argued that this property was already designated for a prior public use because there was an easement for a sewer pipe. And so generally you can take property that's already been devoted to a public use and condemn it as long as it doesn't destroy or materially interfere with the initial use. And the court said here it didn't because the existing drainage easement was for a sewer pipe that's already been installed. So the easement really no longer serves a purpose unless it's to access that pipe, in which case we're just putting a road there. So that doesn't mean that you can't still access it. Okay, threshold issues. Oh, this is an interesting one. Notice. Socha versus Town of Starkey. Petitioners owned property on Lakeview Road that had a shed that was constructed in 2004 after the granting of a variance. The court called it a use variance, but if you read the whole case, it's clear that they meant area variance. Anyways, the shed was 10 by 14 feet, and by 2020, it was deteriorating. It was in bad shape. So the petitioners made an application for another area variance to replace it with a 14-foot by 18-foot shed. So you had the 10 by 14. They wanted to replace it with a larger shed that also required a variance. The zoning board granted the variance in 2021. And then in 2022, based upon that variance, the petitioners got a building permit and they constructed the shed, and it was completed in 2022. Like a month after the shed was done, in November of 2022, the zoning board informed petitioners that the notice for the 2021 variance application was defective, and they had to make another application to the zoning board. The reasons for the defects were petitioner's variance application didn't include the property's address or location, and it had the wrong tax lot number. And in this municipality, the zoning board or their staff sent out the mailed out the notices to the property owners. And in this municipality, it went to every property within 1,000 feet of petitioner's address of the property. So that's a pretty big radius as far as noticing goes. But it wasn't sent to the properties within 1,000 feet of the property where the shed was. It was sent to the properties within 1,000 feet of petitioner's mailing address, which was not the same thing. So no one who lived in the vicinity of that shed and that property had any idea that this application was happening, because when they did the notice in the paper, the property address, the tax lot number was wrong, and that was the only identifying information. And then the mailing notices were sent somewhere else, not to the people who live near that property. So they come back in. So presumably what happened was they put up the shed and the neighbors went to the town and said, hey, what just happened? The town said, well, you got notice of it. And that's probably how all this came to light. So they go back to the zoning board in 2022. And this time the neighbors show up and they express concern about the larger shed. They said it's affecting their access because there's like a turnaround in that area. And so because the shed is bigger, it interferes with their ability to do that. So it creates access issues. And then the increased size of the shed also created drainage issues. So based upon these new comments, the zoning board actually denied the application for this shed that already got a variance, that already got a building permit, that was constructed, and directed that the shed be removed. Petitioners challenged the denial and that claimed they had vested rights to the 2022 building permit that resulted in the shed being constructed. The court said no. Under state law, New York Town Law 267A7, and there's a comparable provision in village law, interested parties are required to be informed of an administrative proceeding by published notice. There was no adequate published notice in this instance because the tax lot number was wrong. So the application, so as a condition precedent to the zoning board taking action on this application, there had to be a notice first. There was no published notice, and therefore this was a jurisdictional defect. The zoning board never had the authority to issue the decision in the first place. So on its face, the 2021 variance approval was null and void. And this is different than just saying, you know, we think your determination was arbitrary and capricious, or we think, you know, it wasn't a substantial variance, or we think it wasn't self-created. You know, this is on another level. It's not the substance of the decision. There was a condition precedent that had to be satisfied before the zoning board could take action. That did not happen. Therefore, the zoning board was never authorized to act. And then the second issue was whether or not they had vested rights. Vested rights is that you have a right in the building permit that you got. And in order for you to have vested rights, it has to be validly issued. So what the court says was, you know what? You probably had vested rights in the 2004 variance, the 2004 special permit, building permit, and the 2004 certificate of occupancy for the 10 by 14 foot shed that you put up back then. But you did not have vested rights in the 2022 building permit because that 2021 variance was never valid to begin with. It was null and void because the zoning board never was able to grant it, which means there's no merit to the 2022. There's no validity to the 2022 building permit. And again, as it comes to estoppel, a municipality is allowed to correct its mistakes. So this had really harsh ramifications for the property owner, but a municipality is not stopped from, if it realizes that something was done wrong, which is exactly what they did here. They realized the noticing was wrong. They made them come back, and no one ever questioned that the board couldn't do that. That was never an argument that was made. What's unique about this case is that generally notice arguments fail, mostly because the person making the argument ultimately knew about the actual application, but, you know, I didn't get my mailing, or, you know, the person down the block didn't get for their mailing, something like that. And courts can pretty consistently say that, you know, imperfect notice doesn't invalidate a decision by the zoning board, especially if they had actual notice, even if it didn't strictly comply with the requirements of the code. This is on a whole other level because there was no notice that was required statutorily by state statute. Shout out to the Rockland County Planning Department, General and Municipal Law 239 and referrals.
Before we get into my favorite subject in land use, let me give the third attorney affirmation code word. The third word is victory. Dodgers fans celebrated their victory recently. So
These are
And
long
that's,
words. I'm used to like bat or,
well, there's a theme behind them, and it's actually
uh,
really hard to come up with five random words. I have to find a theme. So that's just me.
now I wish I had been paying attention. Okay, Cardella versus Zoning Board of Appeals of the Town of Ramapo. The Zoning Board approved an area variance and petitioner brought an Article 78 proceeding challenging the approval. One of the arguments petitioner made was that the Zoning Board failed to comply with the referral requirements of 239 GML 239M. As many of you know, there are certain proposed actions under GML 239M that have to be referred to the county planning department. This isn't just Rockland County, this is all throughout the state. This is state law for their review and comment, comprehensive plans, local zoning laws, special permits, site plan, use and area variances within 500 feet of certain municipal boundaries and landmarks. Planning department or agency has 30 days to provide a response, and the board cannot take action on the underlying application until the earlier of receiving a response from the county planning department or the 30 days expiring. So you have to give them 30 days. If they get you something, if they're really nice and get you something back sooner because you tell them your meeting is coming up, then you can potentially take action. But if you haven't gotten anything back, you have to wait those 30 days. And then if a response is received, you have to address them in your resolution. If it's just, approve, if there's no substantive issues, but often, it could say modify, it could say disapprove, in which case there needs to be a substantive acknowledgement and addressing of what those comments are. So in this case, the zoning board did send the GML referrals out, and the record reflected that the county planning department did respond and that the zoning board addressed each of the substantive comments from county planning in their resolution. And the petitioner failed to demonstrate that the zoning board's responses were insufficient, and therefore this was not a basis to overturn the variance grant. In this one, however, Johnson versus Zoning Board of Appeals of the Village of Brockport. So Earthborn operated a landscape and construction material processing business in the light industrial LI zoning district. And the LI district had certain regulations on these types of light industrial businesses. And one was that all uses shall be conducted in a completely enclosed building. And the other was that no materials supplied or equipment shall be permitted to be permanently stored outside any building. So Earthborn, which is operating this landscape and construction material processing business, says, well, we don't want to do either one of those things. So they went to the zoning board and they sought an area variance. This is one of those uses that's kind of on the fence, whether this would have been a use variance or an area variance. They characterize it as an area variance. I guess you could argue it's some sort of dimensional regulation because it says you have to do it in an enclosed building. They want to do it outside. They want to store equipment outside. So anyway, they called it an area variance. The village didn't disagree with them. It was processed as an area variance, and the zoning board granted the area variance. And then petitioner challenged the approval because the application had not been referred to the county planning agency. No one disputed that it wasn't referred to the county planning agency. The argument was that they didn't have to refer it to the county planning agency. And that is because under General Municipal Law 239 MC3, a municipality and the county planning agency can enter into an agreement providing that certain proposed actions are local determinations, local considerations that don't have to be referred to county planning. And in this case, the county and the village did have such an agreement. And the agreement did contemplate area variances, but not the type of area variance that was being considered here. The type of area variances that they determined were exempt from referral included bulk, what you think of as standard bulk regulations. And again, we're not saying that these have to be ultimately, the case didn't say these have to be ultimately approved, just that they did not have to be referred to county planning. lot area, lot coverage, lot dimensions, floor area, height, and elevation of structures, buffer and landscaping requirements, parking lot size, sign size, height, location of fences, stuff like that. So your standard bulk regulations for a zoning district. Here, the provisions that they were seeking to vary didn't fall within these categories. So it should have been sent to county planning. And because it wasn't, kind of like with the last case that we talked about with notice, there was a statutory requirement that it had to be sent to county planning. It was not sent to county planning. Therefore, the zoning board lacked the authority and the jurisdiction to take any action on this application. But they did so anyway. They approved the variance. And so it got challenged. But it didn't get challenged within 30 days of the zoning board's determination being filed with the county clerk, which is what the statute of limitations would be for an area variance. And the court said that doesn't matter. Because it is a jurisdictional defect, because the zoning board never had the authority to act in the first place, it's null and void on its face. This isn't a case like we were talking about earlier where you don't like the decision or you think it's contrary to the facts or it's not well supported by the record. This is a case where there was a condition precedent to the zoning board being authorized to take action. That condition precedent was not satisfied. Therefore, the zoning board could not have voted on this application. And because of that, because there was no decision, the statute of limitations never started. So I think, they probably waited a couple of months. They could have waited 5 years, 10 years, 20 years, and the outcome would have been the same. At that point, it probably, I don't think, who knows if it would have been there anymore, but because of the level of the defect, the statute of limitations didn't start. And it was never going to start until this was remedied. And so that's what ended up happening. The court had to remand it back to the zoning board for the zoning board to do the proper referral and then try again. As a last-ditch effort, Earthborn tried to argue that it was actually a use variance. And the court said, your application called it an area variance. The board considered the area variance criteria when it issued its approval. You wouldn't have called it a use variance at the outset because then you wouldn't have gotten the approval. Like, don't waste my time. That was basically the gist of it. Excuse me. Statute of limitations. So I'm going to have to start moving faster. I'm sorry. So in 2013, Coden versus Town of Huntington, the zoning board granted parking variances and a special permit. Petitioner sought to challenge them in 2020. Statute of limitations is for a zoning board determination for a variance is 30 days from filing with the county clerk, not 7 years. So naturally, the respondent, the property owner said, and the town said, this is barred by statute of limitations. And so in order to try to get around that, this petitioner tried to use the arguments that we were talking about in the other cases, that it was a jurisdictional defect, it's ultra vires, which means invalid on its face, it's null and void, so the statute of limitations never started to run. And the court said, no, you can't just say it's a jurisdictional defect to avoid the statute of limitations. There actually has to be one. And here it was very evident that there was not one. And so the court rejected that argument and said, even if your claim may have had merit, you should have brought it in 2013, and it's far too late to consider it now. Courts have no discretion when it comes to statute of limitations, other than if there's an argument made that it's a jurisdictional defect, and it actually is a jurisdictional defect, and then they're not actually waiving or extending the statute of limitations. They're saying there was a legal impediment to the statute of limitations commencing, or the time to bring the action commencing. Camarada versus Hubert. Petitioner owns a residential property and applied to the zoning board to replace the garage with a larger one. In April 2021, he got the variances, and this is probably common among many municipalities and zoning boards and planning boards, you condition the approval based upon the actual plan that's submitted. So that's what the board did here. They said, we're giving you the variances, but see this plan you gave us? This is what you have to build. Well, wouldn't you know it? They asked for a building permit to construct a larger garage. And the building inspector originally says, yeah, this isn't too bad. Like, I'm going to give you the permit for it. And then naturally, someone sees it and says, hey, that's not what was approved. So again, after it was constructed, but the petitioner tried to get the permit, tried to do things the right way. And then after the fact, the municipality comes back and says, yeah, we made a mistake. We shouldn't have done that. Now you have to go back to the zoning board and get a new variance. So they go back to the zoning board in 2022, and the zoning board says no. So the petitioner brings an Article 78 proceeding challenging the denial, and the zoning board argues that it's banned by the statute of limitations because they originally got approval for the garage subject to the condition that they follow the plans in April 2021. And the court says no. They're not challenging what was approved in 2021. They're challenging what was denied in 2022 because they submitted different plans. If they had just come back in and just were submitting the same thing over and over again, that would be a different story. But the court explained, a court must first ascertain what administrative decision the petitioner is actually seeking to review, and then find the point when the decision became final and binding and thus had an impact on petitioner. Here, the harm was when they were denied in January 2022 for the larger variance for the larger garage. They weren't aggrieved by the first determination because that's what they were proposing at the time. So it was not barred by the statute of limitations, but because it had been previously determined that it was, this has been 5 years in the making, and the appellate division just decided it and said, no, it's not barred by statute of limitations. So now go back and look at the merits of the Article 78 proceeding. So we might see that in like another 5 years. It's the amount of time that it takes to get these decisions. It's really rough. Ripeness. 10th Street, New York LLC versus New York State Department of Buildings. In June 2018, petitioner applied to construct a 9-story hotel, which was permitted as of right. In December of that year, so 6 months later, the city council amended the zoning code so that instead of a hotel being a permitted use, it was only permitted by special permit. The following month, in January 2019, the building department actually issued a building permit to petitioner for the hotel without the special permit. They realized their mistake the following month. Maybe the petitioner knew it too and just thought maybe no one would notice. Maybe he didn't even know the law was changed, because it happened so quickly right before he was doing his, getting his building permit. So anyway, they realized their mistake. The building department commissioner writes to the property owner and says, the permits are going to be revoked within 15 days if you don't provide sufficient information to us to demonstrate that the permits and approval should not be revoked. So instead of responding to the commissioner and saying, I was about to get a building permit, I shouldn't have to comply with this, or making an application for the special permit, he just goes straight to court and sues the city. And so the city argues this isn't right for review because there's no finality. A determination becomes final and binding when two requirements are met, namely completeness, finality of the determination, and exhaustion of administrative remedies. Here, there was no finality for it to be ripe because all the commissioner said to them was, you need to give us more information or we're going to do this. They didn't provide the information. They didn't make the application. And the inflicted injury or their harm of not being able to proceed could have been significantly ameliorated by further administrative action, by talking to the commissioner or making an application for the special permit. They already had again, we talked about this earlier, a special permit is a low standard in terms of the burden of proof that the applicant has to satisfy. And they already had a building permit for that use. So it would have been worth a shot, and they could have gotten it, and all of this would have gone away. But instead, they went straight to court, and the court said, this isn't right because you could have done more before the municipality to try to avoid having to come here, and you didn't. The other issue was they didn't exhaust their administrative remedies. Before you go to court, if you object to administrative action, you must take all available opportunities that are before you at the municipal administrative level before you go to court. If you're unhappy with something the building inspector interpreted as it relates to the zoning code, if you don't go to the zoning board first, you are going to get kicked right out of court. And here, they didn't exhaust their administrative remedies because they didn't appeal to the zoning board and from the commissioner's communication. And they also didn't seek the special permit. So they could have resolved this all administratively, but they didn't. And so, again, after 5 years of litigating, he's basically told, go back to the municipality and start from scratch. So kind of the other side of the coin, you have ripeness and then you have mootness. Katz versus Town of Hempstead. YBC Holding obtained approvals from the zoning board to construct a new 2-story residence on the property. The petitioners, who are neighboring property owners, brought an Article 78 proceeding challenging the approval and also sought injunctive relief against YBC to prevent the construction of the residence while the litigation was pending. The lower court denied the injunctive relief, but the litigation continued. And while the litigation continued, YBC constructed the house. So mootness applies where there's a change in circumstances that prevents a court from rendering a decision that would effectively determine an actual controversy. Here, you have petitioners challenging the grant of variance, which was to authorize the construction of a 2-story single-family home. The 2-story single-family home has since been constructed. So what has the court actually decided? The question that boils down to, if the court determines the variance was improperly granted, what is the court actually going to do about it? Are you going to make someone tear down a house that they built because the variance was arbitrary and capricious? And this has come up several times. And so there's a framework that the courts follow. And so what they'll do is they look at a fact-specific inquiry. So did construction start? And this is determined whether it's moot. Did the construction start? How far are they in the construction? And how close are they to completion? Was injunctive relief sought to maintain the status quo? Was the construction undertaken without authority or in bad faith? If the property owner just goes and starts building in a rush, that's not going to sit well with the court, and that's not going to be a favorable argument for mootness. If you went to the municipality, if you got all the permits you were supposed to get, if you paid your fees, if you have your notice up, if you're doing everything by the book, that's what the court wants to see. And can the work be undone without substantial hardship? Here it was a 2-family house. That would be pretty substantial. And while they did seek injunctive relief, it was denied at the trial court level. And the court noted, and this has been noted in many cases, if you're denied at the trial court level, you're supposed to go to the appellate division because you can do that by motion. You'll get a quick decision. You have to show that you took every opportunity available, to try to enjoin the person from going forward, but you weren't able to do it. Even if you don't prevail, if you try at every level that you're permitted to in the judicial system, then the courts have said you're sufficiently putting the property owner, the builder, on notice of your intention to stop the development. Because they didn't go to the appellate division, the court said, there was more you could have done to try to stop them from getting to this point. You didn't, so it's moot. I'm going to skip the necessary parties case. standing. There were a lot of standing cases in the past, but there weren't that many this time around. The first one, Copeland versus Town of Highlands. The town entered into a contract with New York Power Authority to upgrade 167 existing streetlight fixtures. They were going to make them, more energy efficient, downward facing. The town board then adopted a resolution authorizing the town to purchase light fixtures from Orange and Rockland Utilities. And then the town entered into a contract with O&R to purchase light fixtures. So you have two contracts, one with the Power Authority, one with O&R, and the resolution authorizing the purchase. So petitioner brings an Article 78 proceeding challenging the town board's actions, basically saying, where was SECRA in all this? SECRA applies to not just to land use applications. It applies to anything where a municipal body, agency, board is approving, undertaking, funding any sort of action that could have an impact on the environment. You need to at least acknowledge it and look at it and say either it doesn't apply, it's a type 2, and I'm going to get into that a little bit later. But basically what petitioner is saying is, you guys didn't do any SECRA on this. There's no acknowledgement of it. So, you shouldn't have done this. You had to do SECRA first before you could take this action. So I guess there was a motion to dismiss, or at least the town made a threshold argument that the petitioner lacked standing. There was no argument in the case that I read as to the merits of the SECRA argument. So to establish standing under SECRA, the petitioner had to show two items: an environmental injury that is in some way different than that from that of the public at large. And it's an environmental injury because that's what SECRA is, an environmental law. And that the alleged injury falls within the zone of interest sought to be protected and promoted by SECRA. So it has to be an injury, and it has to be an injury that relates to environmental aspects. In the land use and zoning context, the court explained, someone can establish standing by demonstrating they use and enjoy a natural resource more than most other members of the public, and the challenged administrative action would threaten that resource. And it's part of the petitioner's burden of proof to establish standing. It's something they should plead in their petition or their complaint, just like you plead your causes of action, just like you plead your facts, in order to be able to establish that you can satisfy all the elements of a cause of action to prove your case. Standing is one of those threshold and indispensable issues, because if you don't have standing, you don't have a right to sue. But the court said here, petitioner did not have standing. And part of that was because once standing is challenged, excuse me, it's not just about pleading the facts that you have standing. Once the town said, well, you don't have standing, then she actually had to prove those facts to be true. And the arguments that she made for standing, the court said they were no different from the public at large. The fact that she liked to walk around the streets at night and, the lights were bright, that's no different from the public at large. She said she had electromagnetic sensitivity. She didn't present any sort of documentation to establish that. Everything else was too speculative or conjectural to demonstrate a specific injury in fact. I understand, standing is important, right? Because you don't want someone watching the news in California and seeing a skyscraper going up in Washington, D.C. and say, I don't like that. I'm gonna bring an article that, I'm gonna challenge that. It would be impossible if everyone could just sue just because they didn't like something that was happening anywhere. You need to be individually harmed. You need to be specifically harmed, and harmed in a way that's different, like the courts say, different than the public at large. What's unfortunate about this case, though, is that I think she was probably right. I think there should have been SECRA done on this, or at least an acknowledgement of it and a determination that if it was a type 2 action or something like that. But if there actually was no SECRA that was done on this, then she may very well have prevailed had she been allowed to bring the case, but she wasn't, so we'll never know. And I'm going to skip over Fraha versus Chateau Homeowners for a Clean Environment, because basically this is just a mishmash of all of the other threshold issues that we already talked about. And I just thought it kind of demonstrates how when you bring an Article 78 proceeding, you throw everything out there. So in this case, there's issues with standing, there's issues with SECRA, there's issues with mootness, there's issues with GML referrals, and there's issues with exhaustion of administrative remedies, all in one case. But because we've discussed all of those issues separately, I'm just going to skip over to SECRA. Voita versus Town Board of Town of Huntington. Petitioner submitted a zone change application to the town board in order to construct an assisted living facility. The town board engaged in environmental review pursuant to SECRA and ultimately issued a negative declaration. Negative declaration ends the SECRA review. It's a determination that there were no significant adverse environmental impacts requiring the preparation of an environmental impact statement. The negative declaration was contingent upon the assisted living facility being connected to the neighboring condo complex's sewage treatment plant. So petitioners challenged the negative declaration, and the court agreed with the petitioners and said the neg deck needs to be vacated because the town board was not in a position to issue the negative declaration without actually looking at the environmental effects associated with connecting to the neighboring property's sewage treatment plant. So the town board said, okay. They scheduled another public hearing. They accepted public comment, including from petitioners and their attorneys. They accepted materials from the applicant, explaining how it would work connecting to the sewage treatment plant. And then they closed the public hearing. And then they waited, and during the next few months, the county sewage agency approved the proposed connection, and the planning board conducted a supplemental review and didn't identify any significant environmental concerns as it related to the sewage connection. So based on all of the supplemental information that was collected over a course of maybe 4 or 5 months between August and December, in December of that year, the town board issued another negative declaration. And again, petitioner challenged it. So there are two different prongs of judicial review when it comes to SECRA. There's the procedural and then there's substantive. And where an agency has followed the procedures required of SECRA, a court's review of the substance of the agency's determination is limited to whether the agency identified the relevant areas of environmental concern, took a hard look at them, and made a reasoned elaboration of the basis for its determination. So you have to actually identify the environmental concerns, you have to take a hard look at them, and then you have to explain why you're reaching the conclusion you are. The review is deferential, as is generally the case with judicial review of municipal determinations, for it is not the role of the courts to weigh the desirability of any action or choose among alternatives, but to assure that the agency itself has satisfied SECRA procedurally and substantively. So that's what the court is trying to do. Did you satisfy it procedurally and substantively? And the court said yes. Procedurally, petitioners argued that the town board should have held multiple public hearings. Court said no, there was no requirement for them to do that. They probably weren't even required to hold one public hearing, but they did. And then they also argued that they shouldn't have accepted supplemental information from the applicant, which is completely counterintuitive. Because the court said get more information, so that's what they did. And especially since they also allowed petitioners and their attorneys to submit information as well. Substantively, they received additional reports and information from a variety of sources, and they set forth a reasoned elaboration for their determination. The petitioners also argued that there were additional environmental issues that should have been considered and weren't. And the court was basically like, let's not get too nitpicky here. You know, an agency complies with SECRA, doesn't have to investigate every conceivable environmental problem. It may, within reasonable limits, use its discretion in selecting which ones are relevant. So in this case, the court was satisfied that they were supposed to look at the sewage connection, how that was going to work, and that they sufficiently did that, and therefore the negative declaration was upheld. So Clean Air Action Network of Glen Falls, Inc. versus Town of Moreau Planning Board. So Saratoga Biochar Solutions applied to the planning board to construct a biosolids remediation and fertilizer processing facility. The planning board determined it was an unlisted action. So just brief recap, under SECRA, there's 3 types of actions. There's type 2, which are as a list that's, they're exempt from SECRA review as a matter of law. They've been determined that they will not have a significant adverse environmental impact. So if something is determined to be a type 2, no further environmental review is required. There's also a list of type 1 actions. Those are the ones that come with the presumption that there could potentially be a significant adverse environmental impact. And those are more likely, the presumption is that they will require, and they could require, an environmental impact statement. And everything that's not a type 2 or a type 1 is an unlisted. So here we're talking about an unlisted. So it does require environmental review, but it's not starting at such a high presumption as a type 1 action. So the planning board required the applicant to prepare a full environmental assessment form, part 1. So environmental assessment forms, there's parts 1, 2, and 3, and there's full and short. Generally, if something's type 2 or unlisted, well, yeah, generally you can start with a short just to kind of get some information out there, but if it's a larger project, you'll do a full. But an unlisted action can use a short or a full. A type 1 has to use a full EAF, and it's much longer than the short EAF. And then there's the parts 1, 2, and 3. The part 1 is prepared by the applicant to give the board some initial information about the project so that it can be typed, or the board can start the environmental review. The type 2 comes from the board, where they identify those environmental areas that'll have no to little environmental impact versus moderate to large. If something's identified as potentially having a moderate to large impact, then there has to be further analysis of those areas identified. And then the part 3 is the determination itself, which either culminates in the negative declaration, which ends the SECRA process, or a positive declaration requiring the preparation of environmental impact statement. So with that said, the EAF part 1, the full EAF part 1, stated the project would generate 96,000 tons of carbon dioxide and 12.7 tons of hazardous air pollutants. The planning board met with the applicant and its consultants and the Department of Environmental Conservation. The planning board identified in the part 2 that there would be a moderate to large impact on air from emissions. And the board made that determination and then issued a negative declaration finding the project wouldn't have any significant adverse environmental impact. The neighbors challenged the negative declaration, and the court agreed with them. If the law, as the court explained it, if the lead agency, here the planning board, finds that an action may include the potential for at least one significant adverse environmental impact, the lead agency must issue a positive declaration and require the preparation of an environmental impact statement. The threshold for a positive declaration is relatively low. A negative declaration can only be issued if there is a determination that there will be no significant adverse environmental impacts. The lead agency has to thoroughly analyze the identified relevant areas of environmental concern to determine if the action may have a significant adverse impact. And again, as we talked about in the last case, this involves taking a hard look at the issue and making a reasoned elaboration for the conclusion that you came to. Here, the planning board basically just said, well, the DEC is going to have to issue a permit for this, and the DEC is not going to let anything happen, so it'll be fine. And the court said, we understand that the DEC knows more about this than you do. We understand this is their area of expertise, and that they are going to have to review this and issue a permit. But that doesn't mean, planning board, that you can just punt and say, well, we're not going to touch that one. We'll just let the DEC deal with it when the time comes. They needed to look into it themselves, even if it was based upon analyses and studies from their own consultants, from the DEC. But to just issue a negative declaration, which means there will be no significant adverse environmental impacts, when you don't know that to be the case, the court said you just can't do that. You have to justify why you're reaching that conclusion, especially on something where there's such large scale potential for impacts based upon how much emission there was going to be. Thousands and thousands of tons. It's a lot. Okay, these next two cases I'm going to do pretty quickly. Cassie versus Board of Education of Cornwall Central School District. So these next two cases are interesting because they kind of deal with similar themes, but on different sides of the spectrum, and you'll understand once I get through them. So the Board of Education was considering constructing a sports field and issued a negative declaration. So dates are important here. On March 14th, 2022, and then updated the negative declaration about a month later in April 2022. And then, I guess maybe they were getting funding, going out to bond. Then they issued a couple more determinations and resolutions over a year later in May of 2023 and July 2023. So like over a year after the negative declaration had been issued. So certain members of the public, petitioners, once the actual formal resolutions had been issued related to this sports facility, sports field, they brought an Article 78 proceeding challenging the school district's negative declaration. And because it's a school district, we're not talking about a planning board or a zoning board. Under CPLR 217, the statute of limitations is 4 months, not 30 days. And again, here, like we saw before, is when does the statute of limitations start to run? In this case, petitioners waited until after the resolutions were issued, which was a year after the neg deck in 2023. And they brought it within 4 months of those resolutions being issued. And this isn't an unreasonable approach based upon the case law. And because there is considerable case law that says that while the negative declaration ends the seeker process, it's not the final agency action because it doesn't actually approve, fund, or undertake anything. It's the environmental analysis, but that in and of itself doesn't create a concrete harm. So often what the challenger will do is wait until the resolution that's come subsequent to it, whether it's the variance, the zone change, the site plan, and then they challenge that determination and at the same time bring up anything related to secret. And that's what they did in this case. But in this case, the court said, and this is not just any court, this is second department. So this is controlling in Rockland, Westchester, Orange, Putnam. They said that petitioners' claims actually accrued with the negative declaration back in March of 2022. And it had a 4-year statute of limitations under CPLR 217.1. And because the petition was not commenced, the Article 78 proceeding was not commenced within 4 months, it was barred by any claims related to the neg deck were barred by the statute of limitations. The court explained that the negative declaration concerned, among other things, the construction of the sports field, and the minutes from the board's meeting on March 14, 2022 indicate that the board did extensive research into the artificial turfs and that the toxicology and overall safety of the materials were discussed. The board's negative declaration constitutes the final determination in this case for the purpose of CPLR 217. So it seems like the court is trying to explain why the outcome is different in this case based upon the analysis and the substance that was in the neg deck. But I have a hard time understanding that, because basically what the court describes is what every seeker analysis should be, is looking at the environmental issues, assessing them, and then making a determination. So why was this case different? Why was the neg deck the determining factor as opposed to the final agency action approving, funding, undertaking the project that came more than a year later? I can't really answer that question for you. So all I can say is be careful. And if you're not sure, file early. It's better to be told you have to come back than to be told you waited too long, because you can't come back from that. Once the statute of limitations passes, that's it. So now we have law that's kind of inconsistent as to whether or not you should challenge a neg deck. And so you really have to look into that when you're making those types of decisions. You can always bring the challenge to the neg deck within the statute of limitations, and then amend it to include any subsequent approval, amend the petition to include any subsequent approvals or determinations that are issued after that. But you should definitely talk to your municipal attorneys about that one, because this one is a little confusing for me. In contrast, Haunted Forest LLC versus Town of Wilson. Here, petitioners sought a renewal application for a special permit. They already had a special permit, they were renewing it, to conduct a Halloween-themed event on their rural property. The town issued a positive declaration. So they want to hold a Halloween event on rural property. They've done this before. They're getting a renewal special permit, and this one gets a positive declaration. They don't say what the potential adverse environmental impact is, but it requires the preparation of an environmental impact statement. So petitioners go to court challenging this, and the court says it's not right for judicial review. And the argument is basically that it's not a final agency action. All they're saying is you have to prepare an environmental impact statement. So once you prepare your environmental impact statement, and once the findings under SECR are done, and once the special permit application is decided, then you can challenge your determination of the POSDEC that you have to prepare an environmental impact statement. At which point, if I were on the other side, I would argue it's moot, because you've already gone through the entire EIS process at that point anyway. But the court explained that to permit judicial review under the circumstances of this case would have the inevitable result of rendering every positive declaration right for review merely because the preparation of a DEIS by its nature carries financial costs that generally cannot be recouped, regardless of the outcome of the SECR process and the ultimate determination on a petitioner's zoning application. I mean, yes, an environmental impact statement process is lengthy and costly, but sometimes I think depending upon the project, it's more efficient. There's a more streamlined approach. You know exactly what you're doing, as opposed to when people sometimes try to do an expanded EAF process, and then you're constantly submitting new documents and supplementing, and it's hard to keep track of what you're preparing, what you've submitted, especially if you're on the board, right? And you have an application that's been before you for a year and 18 months, and you've had like 4 different versions of the traffic study submitted, drainage analysis, zoning analysis. I don't know. I do think under certain circumstances, there is a benefit to just going through the EIS process. You know exactly what you're doing. You know what the process is. You know when you're getting comments, and it can be easier for everyone involved because you know where all the documents are. You know how it's structured. But that's just me. But as I alluded to when I started talking about this case, I'm disappointed by the lack of facts associated with it, because I really find it hard to believe why they issued a positive declaration. Something must have happened, or people didn't like the event. Maybe it brought in too many people from out of town, created too much traffic. But for something that's seasonal in a rural area, to POSDEC it, something must have been going on. Okay.
If I could jump in for two things. One, I'll give another attorney affirmation code word. This next one is concession, as in the concession stand at a ballpark. I also wanted to interrupt because there is a seeker-related question in the chat. Uh,
Okay.
Generally, people wait to challenge neg decks until decisions are made, but what about challenges to a scoping outline and a decision to proceed with a segmented review? It doesn't make sense to wait for the wrong EIS to be developed and then challenge that down the line. Is a challenge to a bad scoping decision ripe?
A bad scoping decision. So it, I, in that someone saying it incorporates too much information, or someone saying it incorporates too little information, or you just feel like you're aggrieved by what's in it or not in it. I'm inclined to say no. If a positive declaration isn't ripe, then a scoping document, it's all part of that same process. The scoping document is just the outline, the table of contents, so to speak, for the EIS. But I mean, the scoping document should be at least to some extent based upon the positive declaration, because the positive declaration has to identify those moderate to large potential impacts that are going to be analyzed in the EIS. But I mean, I don't know of a case where a scoping document has ever been endeavored to be challenged before going through the EIS process. There may be one, but based upon the case I just talked about, where the pos dec wasn't ripe, if that's not ripe, I don't think a scoping document would be.
There was a follow-up. What if the whole action is not being considered?
I don't know what that means. The whole action is not being considered.
I
Then
think
what's
it's a question
then
about
what's the pos dec?
segmentation.
For segmentation, I think you would, well, segmentation isn't always impermissible. I mean, I don't have any cases on segmentation, but segmentation isn't always impermissible. You just have to justify why you're doing it. And that it's not going to be, and that by separating them out, it's not going to be less protective of the environment. The secret regs say that. So, segmentation gets a really scary connotation associated with it, but it's not like these jurisdictional defects where, you say segmentation and everything goes out the window. If something is being segmented, I don't think you can, I would say, make your record during the secret process so that when you go to court, when the secret process is done, you can say, I raised this and it was arbitrary and capricious for whatever board was serving as lead agency not to address it.
All right, I'm just going to hold any questions till the end since we are getting low on time. So I'll let you power through the rest of it with hopefully no interruptions.
Okay, I'm going to skip the first wireless telecommunications case, New Singular Wireless versus Incorporated Village of Muttontown. We talked about this case last year, and the court actually ended up dismissing it because the pleading didn't sufficiently allege the claims. So they were allowed to amend their complaint and come back, and the court found that they did sufficiently plead claims. But since it's not on the merits or the substance of the claims yet, I'm sure we'll be seeing another motion decision on that in a year or so. But this next case, Weiss Towers LLC versus Kootenai County, Idaho, I liked this case because it engaged in a good good legal analysis of the issues that I found easy to understand, and then the factual analysis. So the county denied plaintiff's application for a conditional use permit to construct a 150-foot wireless telecommunications tower, and plaintiff commenced this litigation. under the Telecommunications Act, the Federal Telecommunications Act, the intention of which is to encourage the rapid deployment of new telecommunications technology while preserving the authority of the state and local governments over zoning and land use matters. So you have the federal interest in getting the technology out there, the local interest of preserving their zoning and communities. So to balance these interests, the TCA preserves authority in local governments on zoning decisions regarding placement of construction of wireless facilities, but with limitations on the authority. So two of those limitations are whether the municipality, here the county's actions, constitute a prohibition on services. So is the action taken by the county prohibiting the wireless telecommunications company's ability to provide these services? And the second is a substantial evidence claim. And that is more akin to an Article 78 proceeding. That's looking at the local laws, the zoning regulations that are in effect for these types of uses, and seeing if the zoning board's determination to deny the application, or the county's in this case, was based upon substantial evidence. So the court looked at substantial evidence first, because that's a more narrow view. And so, but even if there was a denial, which there was here, and it's supported by substantial evidence, it could still constitute a prohibition on services. So the court started with the more narrow analysis. To be substantial, evidence must be more than a scintilla and less than a preponderance. And if you're confused by what that means, you're not alone. But then it goes on to say, and consist of such relevant evidence as a reasonable mind might accept as adequate to support a conclusion. So if you think about it this way, in an Article 78 proceeding, is something arbitrary and capricious? Does it have a rational basis? You know, it's pretty much, is it justifiable? Here, we're higher than that, the substantial evidence standard. You need relevant evidence, and the court's looking at the entire record. They're not just looking at the evidence that supports your position. They're looking at the evidence that doesn't support the denial too. They're looking at the total accumulation of the evidence that was before the board, and of that, a substantial amount of legitimate evidence has to support the denial. It is still deferential to the board, to the county in this case, but it's not a rubber stamp. And the court does not have to accept evidence that's impossible, incredible, unfeasible, implausible, even if it's unrefuted. The court has to consider it to be legitimate. So in this case, because it's the utility bringing the claim saying that there was not substantial evidence, it's first incumbent upon them to prove that. So in this case, in order to determine whether there was substantial evidence, the court had to look at the county's own regulations as to what was required for a conditional use permit for a wireless communications facility. And in this case, the county said there were two conditions of the code that the plaintiff didn't comply with. It didn't show that the proposed tower would be compatible with existing homes, businesses, and neighborhoods and the natural characteristics of the area. And two, it did not adequately address site constraints or hazards and adequately mitigate negative environmental, social, or economic impact. So the court basically went through all the arguments that the county made one by one and just rejected them. Starting off with the easy ones, NIMBYism, not in my backyard, and just a desire to not have a cell tower near them was not a basis to deny an application, because it would completely frustrate the purpose of a statute. Someone could just say, I don't want this. Okay, no problem. Then what are we doing here? Another person said they didn't mind the gaps in coverage because it was part of the Idaho lifestyle. The court didn't like that one. The aesthetic impacts argument from the cell tower wasn't considered seriously either by the court, because it was just generalized community opposition without substance. And the court found that where people were concerned about aesthetic impact, they hadn't actually done any of their own homework or investigation. They didn't know what the cell tower is actually proposed to look like. They were talking about cell towers generally. One guy took a picture of his view from his backyard and then superimposed a cell tower next to it, and as though that's what it's actually going to look like. The utility had done a balloon test, which I'm sure some of you are familiar with, right? When you have big projects or high projects, the applicant will do a balloon test so you can see how high it's going to go up. The balloon test showed that this was going to be barely visible because the elevation is lower where it was going to be, and there was high tree cover. You were barely able to see it. But yet people just said that there were aesthetic issues just because they didn't want it. And you just assume, because you think 150-foot cell tower, it's probably going to be pretty visible. But in this case, it really wasn't. And the court saw through those arguments. Fire risk. The court did acknowledge, obviously, public safety is important, but the county's fire and rescue district had actually reviewed and approved this. There was also concern about fire from lightning strikes because obviously it is a conductor, it's higher up, it could be more likely to be struck. But the studies that the public provided to support that were based upon structures that were 4 times the size of what was being proposed. And this was a repetitive theme where, there was theoretical evidence as to what could happen, but nothing that showed how it was relevant to this area, to this project, to this type of analysis. And it was the same thing with the argument for decreased property values. First of all, to the extent people expressed concern about health effects from radio frequency emission, the Telecommunications Act has said for years and years that this cannot be a basis to deny a permit, that there are no identifiable health issues, and just putting it in there, you lose credence in any argument you make. And then the other issues, kind of like I mentioned earlier, is that as it related to decreased property values, they were all like general studies or studies that had no applicability. They provided one study about the impact of cell towers on properties in Savannah, Georgia. There was no analysis of how far these cell towers were, how visible these cell towers were. So, the court really couldn't say that constituted substantial evidence. So even though the court's already decided the compatible use permit should have been granted because there wasn't substantial evidence to deny it, it still went through the analysis of the prohibition on services claim and established that the board's denial did actually result in a prohibition on services. And in order to demonstrate that claim, you have to show that there is a significant gap in coverage and that the application proposes to address that gap by the least intrusive means. So you have to show that there's no less intrusive, there's no more accommodating way to do this than the one that you're proposing. And that's a pretty high standard. So in this case, the utility was pretty easily able to establish there was a significant gap in coverage because there was a 12-mile gap on the highly trafficked I-90 corridor, which serves 15,000 cars a day. So that really seemed like a no-brainer. No one even questioned that. And then to determine the least intrusive means of coverage, you have to show that you really meaningfully considered other alternatives. You really thought about what was required, what you needed to achieve. Were there other locations? Were there other designs? Were there other formats or technology that could solve these problems? And were they less intrusive than this? And so plaintiff went through and showed everything that they looked at. One location wouldn't sufficiently cover the gap. One location lacked infrastructure. There was no road access, no electricity, no fiber optic sources. The Forest Service had a location that could have potentially worked, but they refused to even talk to the utility until they had exhausted all other avenues. And so the court basically said, it's not fair to plaintiff to have to keep getting rejected and rejected and rejected until the Forest Service finally says, okay, well, we think we've tried hard enough, so we'll talk to you now. That's not the standard, and that's not what they're required to do, to endure repeated denials by local municipalities. And the county couldn't really sit on their high horse saying that they didn't, that the utility didn't adequately consider alternatives when the county didn't actually provide any themselves. And then we've seen this in TCA cases before, because it is the objective is to make these decisions quickly. We've talked in the past about shot clock, the statutory timeframes to take action. By the time it gets to this point, the utility has lost a lot of time litigating and trying to get the approvals. So what they'll often say in a remedy that's available under the TCA is not just for the court to do what it would do often in an Article 78 proceeding and send it back to the lower court or to the board for further consideration. Here, the court issued an injunction to the county saying, issue this permit. We're done. There's no discretion left to you. You had your chance. You didn't do it. So we're sending them back. Get the permit issued now. And so that's what they did. So Savannah Forest Retreat versus County of San Diego. A Buddhist minister acquired 10 acres of property to operate a meditation center. They began operating meditative retreats and installed 10 yurts, which are like little teepee, circular teepee type things. The application was submitted in 2021, but the county didn't process it for 2 years. They would come out and visit the site. They were very concerned about the yurts because they presented building and fire code issues. And then when they went out to look at the site in 2024, the county observed that there was illegal discharge from the yurts, unauthorized electrical, gas, and plumbing, all of which were building code issues. So the county basically said, get rid of these structures and you'll only need a minor permit. You'll have your approval for your meditation retreat really quickly. And the court basically said, they said, no, we don't feel like doing that. We're just going to bring an RLUPA claim instead. They brought an RLUPA claim arguing it was a substantial burden on their exercise of religion. But RLUPA deals with a zoning or landmarking law that limits or restricts a claimant's use or development of land. Here, the issue wasn't a zoning or landmarking law, it was the state building and fire code. And so the court said, this isn't a zoning regulation that's even regulated by RLUPA. This is like this is a health and safety issue, which I guess zoning falls under the scope of too, but it's different. And they cited to the Fortress Bylaw case, which came out of the Second Circuit, which is where we are. But in that case, the issue was SECRA, and SECRA has to precede any zoning approval. And in that case, in the context of the SECRA determination or review that had to precede the zoning consideration, they were using that. The allegation was that it was being used as a way to prevent the zoning from ultimately going into effect. That wasn't the case here. They were the building code and the zoning code were completely separate things. And the county just kept telling them, just comply with the building code, and then you'll be able to get an easier permit and we'll work with you to get it done. And they just refused to do it. They also argued that there was an RLUPA violation for the enforcement of their zoning code. And the court said that's not right because you never actually made an application. You just refused to do everything that the county is telling you to do. So ultimately the court said, you don't have a claim and you have to do what the county says. Otherwise you can't just, say RLUPA and get, be able to do everything. Miller versus City of Burien. A Methodist church was currently operating in a multifamily residential zone. The church wanted to create an encampment for 100 unhoused individuals in its parking lot for 3 months. The uses did comply with the zoning, but the property owner was told they should submit a temporary use permit. They didn't submit our application for a temporary use permit. They didn't submit the application, and they did the encampment anyway. The city issued a violation, the encampment stopped, and then the city rescinded the fines, and they kept going around in circles like this. The church wanted to reinstitute the encampment, but instead of just filing an application, they brought an RLUPA violation that it was a substantial burden. Congress passed RLUPA to protect the free exercise of religion from government regulations, but this is not carte blanche. This is what the court said. The plaintiff must demonstrate that the regulation at issue actually imposes a substantial burden on religious exercise. In this case, the city didn't dispute that the encampment was in and of itself a religious use, or a religious exercise, which, they probably actually could have. But the issue was whether it was requiring them to submit this 2-page permit was actually a substantial burden on the religious exercise. And in this case, the court found it wasn't. The court noted that several jurisdictions, including the Second Circuit, have held that the requirement to comply with land use regulations in and of itself does not violate RLUPA. The court cited the Westchester Day School case out of the Second Circuit in this court, which stated that the court must ensure that the facts warrant protection under RLUPA rather than simply granting blanket immunity from zoning laws. So the court looked at the specific facts. The city had been very accommodating to the church. They waived permit fees, they waived violation fees. They showed they were willing to work with the church. And there was nothing in the record to the contrary that the court could point to. It was a short application, 2 pages, and it was just intended to make sure that the health and safety of the residents were being accommodated. But the church refused to submit the application. So because there was no evidence that it was a substantial burden, the court found that there was no RLUPA claim. And I'll leave be the bush for the spring.
All right. Well, yeah, we're at 9:32, so we're a couple of minutes over. So I think
Sorry.
I'm impressed not only with your knowledge, but your endurance and your ability to keep talking. I would have been long horse by now. So thank you very much for doing this. Also, just want to say thank you to everyone out there, not just for being here tonight, but for volunteering your time and giving it to your community. It's a thankless job, so I always try to end these by saying thank you for all your hard work and effort. Just a heads up, if you do need a certificate of attendance, please shoot me an email. Everyone who was online today will get an email from me tomorrow with the attorney affirmation form and a little survey form. And only attorneys looking for CLE credit need to return that to me. But if you want to, please go ahead. I'll be happy to take any comments that you want to provide. And I don't know if there's any questions. I'm seeing a lot of thank yous in the webinar chat, but I can officially end this, and I'll stop the recording, but I'll stick around for a little bit if Christie, if you don't mind sticking around. There might be a question or two, but it is late. I understand if people want to get off and go to bed. So thank you all very much.
Or drive 45 minutes home.
Thank you all, and everyone have a good night.
Good night, everyone. Thanks for coming. Happy Thanksgiving.